Welcome to the Jail and Corrections Reform Task Force. This is meeting number 6, Wednesday, November 8th, 2023. I'm being advised by staff that we need to approve the minutes of the last two meetings. We will first accept the motion on September 26th. Do I hear a motion? I hear a motion. Is there a second? Motion's been made and seconded. All in favor use voting sign of aye. Anyone opposed, like sign. Let the record reflect the minutes for September 26, 2023 have been adopted. Now we will do October 23rd, 2023. Do I hear a motion? I hear a motion. Is there a second? A motion's been made and seconded. All those in favor use voting sign of aye. Anyone opposed, like sign. Let the record reflect that the minutes for October 23rd, 2023 have been approved by this task force. Madam Secretary, call the roll.
Senator Storm, Senator Webb, Senator Westerfield, Senator Wheeler, Representative Hell, Representative Herron, Representative Petrie,
Here.
Representative Williams, Co-Chair Schickel,
Present.
Co-Chair Bray.
Present.
Let the record reflect we do have a quorum and are duly constituted to do business. We have an agenda this morning. We are going to go to first item number 4, felony sentences in the Commonwealth, the Kentucky Circuit Judges Association. Welcome from Northern Kentucky, Kenton County Judge Summy and Campbell County Judge Ward. Good friends of mine. It's great to see you here testifying on behalf of your association. Introduce yourself for the record and proceed with your testimony.
Be here, and it's great to be recognized. My name is Patricia Summy. I am a circuit court judge in Kenton County and am past president of the Circuit Judges Association and its current secretary.
I'm Julie Ward. I'm a circuit judge in Campbell County. Again, thanks for inviting us to be here. I'm a general jurisdiction judge. I am the chairman of or co-chairman of the Education Committee, and I'm also the second vice president of the Executive Committee of the Circuit Judges Association.
So do you wish me to proceed then, Chair?
Yeah, why don't you go ahead and proceed with your testimony, and then we'll have comments from the task force after your testimony. You can go ahead and proceed.
All right, thank you. First, I want to recognize Cole Mayer, who's with the 25th Circuit. She's also with us, one of our newer judges from last year, so we appreciate her starting to become involved. And I also want to state that the association we don't speak for the association. We try to gather information from the association for you, but of course each individual elected judge has their own opportunity to speak, and they have sent us some comments, so we hope to share those with you. It's my understanding the committee had some questions about the use of pre-sentence reports by the circuit judges and the delays that may be caused in that sentencing. Under KRS 532050, the judge is required to order a pre-sentence report after conviction of a defendant, either by plea or jury verdict. A defendant in custody may waive the preparation of the report before sentencing, which means after sentencing then the DOC is required to move forward and prepare that pre-sentence report. This report takes anywhere from 4 to 6 weeks to complete, either before or after a plea, for sentencing if the PSI is waived. In Kenton County, it takes 6 weeks to have a PSI prepared and sent to me for use in sentencing. And it is this report that is my understanding that is used by the DOC to classify the defendant. The information gathered by DOC, and this may be repetitive for you, and I apologize for that, through the Probation and Parole Department is risk and needs assessment, analysis of criminal history, family situation, background, economic situation, education, occupation. It also includes physical identifying information for the DOC, so they have that if there's incarceration involved, and includes also identifying counseling, treatment, educational needs of the defendant. And the defendant, of course, has the right to challenge all the information in that PSI to assure that it is correct. It is important information, and I think that the public defender and the judges agree on that. It's important information, and for the judge to determine in the plea recommendation of jury sentencing, and which helps us to assure that our sentencing conforms to community standards and also to equality of sentencing. By that I mean to make sure that those persons who have a certain type of criminal history as well as background are being sentenced kind of in the same range, so that you don't have anybody who is suffering from unequal sentencing practices. We have not done a survey of the judges, but the comments received indicate that the PSIs are required by many judges and are waived by many judges. And so I think that Judge Ward will later talk about why that is, but judges have very many reasons to do that. In my jurisdiction, if somebody already has a PSI and it's lesser included, or it's a smaller charge like a possession of controlled substance, I'll waive it and sentence them so they can move forward if it's a consecutive sentence. So there are a lot of reasons you'll waive it. I generally don't, because in my jurisdiction, the Commonwealth Attorney will generally recommend a sentence that says that the defendant may argue for probation, so I want to be fully informed so I can make sure that they have that opportunity to have probation depending on what their PSI says. It came to my attention as the president of the association about maybe 6-8 weeks ago that the DOC was concerned about some receipt of sentencing orders, and I don't know if that's part of the reason that we're here today. But we looked at the grid provided by DOC to AOC, and in fact, I went through 3 of the cases that were in Kenton County. Thank goodness there were only 3 cases in Kenton County, but I did go ahead and look at those. And statistically, if you had that grid, and I won't go through those numbers with you if you did have that grid from DOC, but statistically back in August, 39% of 120 or of 319 judgments, or 126 were filed within 7 days. 18% or 57 were filed within 14 days, and 13 or 41 were filed within 30 days. 49 or 16 were filed within 60 days, and 10% or 32 were filed within 90 days. The AOC looked at these numbers and the time anomalies, and we discovered that there was a problem in one of the circuit jurisdictions having to do with staff illness and some dockets, and so most of that has been cleared up, which is reflected in the October grid. And again, I don't know if DOC has shared that October grid with you, but that reflects that within 7 days, 60% or 184 of 200 sentencing orders are filed within that 30 days, and the majority of them really within the first 14 days. So I think that like we can all get better at what we do, just letting us know that there's a problem allows us to fix it as opposed to allowing it to become a problem or something that's been systemic. I also want to say that we have never had this problem before, so it was only when we were notified those several weeks ago that we were aware that there was some problem in certain jurisdictions, and so we're working towards working with that, as are all the judges who were made aware of the concern by the Department of Corrections at our circuit judges college just a couple weeks ago. So everybody's got it on their radar. Well, I have only been investigating since yesterday when we were asked to testify, and specifically in Kenton County, it appears that different dates for guilt and receipt of sentence orders may have been used in the calculation of the timeline. So I took the 3 cases that we had, and they were not 72 days old. They were only 45 days old, which is within that 6-week period of time where I have to wait to get that order, that information, so I can go forward in sentencing. One of those cases was a murder trial, and actually the date of the judgment started running from when it came back from appeal, and the judge actually had to enter an order to have the defendant moved. The other 2 were strictly within the timelines, with the judgment being filed within the 45 days, so I'm not quite sure where the calculation or the audit difference is, but I did look at those to assure that we were staying on task. So to answer the first question that I believe that I received from your staff is that it takes up to 6 weeks for probation and parole, if fully staffed, to complete a PSI. The defendant is then sentenced on a set docket, and it may take 2 weeks to produce a sentencing judgment depending on the court schedule. So if I sentence on a Tuesday and start a trial on a Wednesday, and my staff prepares all my documents, I may not get around to reviewing that if the trial went all the way through Friday until either Tuesday or Wednesday, because I have 2 docket days each week. So I have 2 criminal docket dates every week. So I may not get around to even reviewing that judgment until the following Wednesday, and so I'm already 7 days out. So if there's something wrong with that judgment, then we have to reproduce it and needs to go downstairs, at which it might spend a few days with the clerk. So that's a normal span. So we're pretty convinced that anywhere from 14 to 30 days is an appropriate amount of time, because, actually sometimes you may not be in the office for 2 weeks. We were all at Circuit Judges College, or, we take some time off like everyone does. And so if the judgments were done before you left, that may cause some of those problems. That's a typical schedule across the Commonwealth, and I know that multi-counties have even more challenges in terms of going from courthouse to courthouse to get their paperwork done. Other things that may cause length of time between pleas and sentencing, which happen on a regular basis, is that the defendant may have picked up additional charges, and thus that has moved the sentencing back because they want to take care of that prior charge before they are sentenced in the pending charge before you. The defendant wants to withdraw their plea, so you've already entered a guilty plea, and the defendant then wants to move forward with a hearing on withdrawal. That comes back and there's not a substance abuse evaluation, and you want to make sure that you have that done, or a mental health evaluation, and that's not done. The defendant fails to appear for sentencing, so now all of a sudden you're moving that out because you have to bring that individual back before you to proceed. And then there's, of course, staffing and staffing responsibilities. My secretary, of course, is busy calling jurors, setting up all those kinds of calls, and doing everything else. So some of that is staff-oriented in terms of clerical and preparation. And then again, across the Commonwealth, it's about docket size. And so we have a pretty hefty docket in Kent County, and so to the extent that we're moving cases every week pretty quickly, that will affect the amount of time it takes to get something in. The other issue, of course, is intricacies of the sentencing situation, including victims testifying, sex abuse evaluations, and including that the PSI corrections are in the judgment. So if I'm at sentencing and the defendant says they want me to just put the corrections in the judgment, I'm required to do that, and they'll say this is incorrect, this is incorrect, this is incorrect. It makes preparing that judgment a little bit more intricate, and so when I review it, I have to make sure that that's in there, and that's not just something that my staff can accomplish. The next question dealt with delays because of waiver of the PSI. Judge Ward will speak with various reasons a defendant might waive, but if I sentence immediately because the defendant is already a state prisoner, or I'm aware of most of the information I believe I need to sentence, that classification at the DOC, it's my understanding, again, from conversations we've had in the past day, that takes 4 weeks as well. So the classification process is going to be 4 to 6 weeks, whether we sentence immediately or we sentence when they're before us. So that was my portion of answering your questions. If you have anything for me, please let me know. But Judge Ward will now address the third question about why, from our perspective, a defendant may waive their PSI.
Thank you for your testimony, Judge. The first thing I want to do as chairman or co-chair of the task force is apologize to you for the short notice. We were brainstorming just a few days ago because this is our last scheduled meeting, and we were thinking, what have we missed? What have we missed? And alert staff called this to my attention, and I think they were right on point, because this is definitely something we want to cover because it comes up often. But I do, to come down here on 2 days notice, I think is a lot, especially with your schedule, and so I appreciate you being here.
Appreciate being asked.
Yes. Judge Ward, proceed with your testimony.
Yeah. I don't have a lot. I just want to a little bit reiterate what Patsy said, is that it's difficult because I'm not sure with the Department of Corrections as to when their time clock starts in terms of the delay in sentencing.
Hold on just 1 minute,
Yep.
Judge. I don't mean to interrupt you.
Yep.
Is there anyone from the Department of Corrections here? Okay. Proceed.
Yeah, the reason I say that is because the Department of Corrections gave AOC a list of cases in which they thought the sentencing was delayed. And I didn't look at all of them because there were several, but I did pull up one just to sort of get a gist of have an understanding. And the one that I pulled up, I couldn't see more than a 4-week delay at all. And that was from the date of the plea to the date of the sentencing, which would be very normal because it would take that judge at least 4 weeks to get the PSI. Our probation officers in Campbell, we share them with Boone, Kenton, and Campbell share probation officers. And when I first took the bench, I asked them if they could get me the PSI in 4 weeks. They said 6 and I said 4. But what I didn't realize at the time is that I was impacting other judges because those judges were then being still moved to 6 and sometimes 7. You start to learn that as you go on a little bit. But you get that PSI, of course, and then as soon as you get the PSI, you sentence the defendant, and then obviously some things can cause the delay, as Patsy just mentioned. So if they're using that time frame between plea and sentencing, then that explains why there's a delay to get that PSI complete. But I also think that they consider people who have violated their probation. So if someone's violated their probation or diversion, if someone's violated the diversion, they'll come back before the court for a sentencing again. So you have to get another pre-sentence investigation report completed. In that circumstances, the statute doesn't say you can waive that PSI. So you get that pre-sentence investigation report, and that takes a little bit of time. So if they're using the time of the arrest, then again, it could take a while to get the hearing for the revocation, and then there's a whole sentencing order and findings of facts, and it's sort of involved. So that takes a little bit of time too. So it would be really important to know when they're starting that clock. But in terms of me, in terms of the delay for the waiver of the pre-sentence investigation report, I can think of several reasons. I would think that probably they think they're going to meet the parole board quicker if they waive the pre-sentence investigation report. That would be my guess of the big motivator. I do think that there are times that defendants don't want me to read the pre-sentence investigation report because there's things in that report that I don't know, that I can't see. Some of the things that PSI will tell me is they'll tell me how many times they've had treatment. They'll tell me how many times they violated their parole. Those are very important factors for me to look at. They'll give the whole criminal history. So I can see a defendant doesn't want me to see that and maybe want me to accept the recommendation that the Commonwealth has given blindly. I don't really like to do that. I like to know before I sentence. I think I'm not the executive branch of government. I'm the judicial branch. I think that's my job, to use independent decision making. And I think defendants also may waive because they think that they are going to get classified sooner, which, as Patsy mentioned, that does not happen. Our jail in Campbell County told me yesterday that it still takes 4 weeks to get the classification, or if they are classified, it's not a full classification, it's a partial classification. And in Campbell County, they're almost always going to be classified as a medium risk, and our jail does not have any work for a medium risk person. You have to have a 1 or 2 to get any work release or any programming in the Campbell County jail. In addition to that, I don't really know if I understand this. I haven't talked to anybody from DOC, but apparently, I guess if you're not classified, that you cannot work any programs and get credit for it later. So if you're pretrial and you do a SAP program, you're not going to get credit for that later if you get sentenced. I'm not sure if I understand the reasoning behind that. Maybe there is good reasons. I just don't know. So I was a little surprised by that. But the waiver doesn't seem to help them anyway. So I don't necessarily know what benefit it would be other than to meet the parole board potentially quicker. The only other thing that I could possibly imagine is that maybe they just are tired. They want to be done. They don't want to keep coming back to court. I know when they come back to court, they get a pat down, they get to get in the jail, then they have to sit in a little cell in the back. So that could be a reason why. There's probably a lot of other reasons, but those would be the ones that I could potentially think of as a judge. A judge's perspective. So thank you all.
And if I can add, the other thing and another reason is, and we've talked about this just before we came up to testify, is that they can't get into any services if they have something pending. So if they have already been sentenced to something and they could go to a program, if my sentence is pending, they can't. The DOC will not send them to a resource. So I can't just say the recommendation from the Commonwealth is probation. The odds are this person's going to get probation. They will have to wait to get services until I sentence. And so that is another reason that, if you waive and they waive and you want to go ahead, you do, so that you can get services through probation and parole, because otherwise it would cost them money. And they may already have a bed set up and not be able to go. So that's another reason that they may wish to waive their PSI.
And one other thing, I will tell you that in Campbell County, I know Kenton does it too. One thing we do to try to assist our probation officers is that after a defendant is pled guilty, we will email our probation officers and let them know they've pled guilty. we'll give them the date of the sentencing so they can start getting that PSI complete. And then a lot of times after we sentence, we'll actually fax or email the sentencing order to them. In Campbell County particularly, they've asked us not to do that. They ask us to put it in a bin for them. So they have a bin every day. They can come to the courthouse and pick up their sentencing orders. So we do try to assist them to the best of our ability to try to make the process be a little bit faster and quicker for them also. So those are just some things we do.
Right. In Kenton County, we give them the whole packet, and I order them to go to probation and parole immediately with the packet. Take the packet over there, make your appointment for your interview. So we try to assist it, and you know, and there's lots of room for everybody's improvement. But as soon as I have a PSI, I can sentence. In many instances, I can't sentence unless I have a PSI.
Judge Ward, I want to apologize to you also for such short notice coming down. Ditto on what I said to Judge Summy. It's a shame that the Department of Corrections is not here. Something that involves them so much. I'm a little disappointed. Again, I'm going to ask if there's anybody here from the Department of Corrections. They have, you know, if you have an office right here in town, a liaison officer with the legislature, you would think that would be one of the duties, that you would be at a task force on corrections, but I don't see anyone, unfortunately.
I did bring a couple of PSIs that you can't see because then I'd have to kill you. But if you notice that they're rather lengthy, and you know, and so we will, you know, this is my notes that I pull out of them and put on the front, so that when I'm actually, after I've read them, and you can't sentence right away when someone's in front of you because it's a lot to read. So there's always a sentencing document. So we go ahead and make all the notes we have and who's in Boone and make all the corrections. And so it's complicated, and the defendant wants, this is the document that follows the defendant. So it's important that it's correct for the defendant.
Judge,
important.
I've been out of this business a long time, and I know as a former jailer, the first thing on our minds is what day do I start getting paid?
Yes.
for this
Correct.
prisoner?
Yes.
Correct.
But I'm and this is a very elementary question, but so they can just waive these.
They can ask to waive, but we don't have to, because as a judge, obviously, to sentence them, it's really important for us to know all those factors. I mean, they can ask, and we can say yes or we can say no, depending on the circumstances. If we have
What percentage of them are being waived? Do you have any
in
idea?
Camel, I would say I don't do a lot, just because I think it's my job as a judge to make sure that I'm sentencing appropriately. I'm not just a rubber stamp anything the prosecution wants to do. But if I know a lot, like I sentenced someone recently where he had a possession case, we already had a PSI, then he bail jumped. And when we came forward for the plea of bail jumping, I sentenced right away. I already had the PSI, I already had information I needed.
Right.
There's no need to continue on. He wanted to waive, so. But I will if I can.
I want to recognize who I consider one of the experts on this subject, Representative Petrie.
Thank you, Mr. Chair. Thank y'all for your presentation. And so there are legal requirements, and then there are practical concerns, and those differ between jurisdictions.
Sure.
From this committee's task force perspective and things that have been spoken of before, yes, a guiding motivator is how do we get someone who is incarcerated into programming as fast as we can, so they can start to build that traction toward their exit. That's what we're looking for. And so we hear from DOC about the things that may prevent classification from taking place, and that's the magic event that gets you to service rendering in the programmatic arena. There can be different ways, and I don't like the waiver of a PSI. And there are circumstances that I can imagine where it would be appropriate. DPA can talk to those things also. But what I consider is something that you said, I was hoping somebody would get to it, that once you plead guilty and then there's a PSI done, that PSI is now your biography from then on. That process, as well as every other process that you have, that's your biography that's built from then on. If there are inaccuracies in it, everything that follows will be inaccurate to a degree also. So I don't think that it can be done in less than 4 to 6 weeks from the date of a guilty plea. Order it done, speed it along 4 to 6 weeks. Really the pivot point event I'm looking at is its sentencing. So if we have a PSI that's done reasonably within 4 to 6 weeks, and we could work on shortening that, not because of y'all necessarily, but shortening that at the sentencing point, making sure is there, and this is, I'm sorry to get to this at the long end, but really the question from me to y'all to either answer today or later would be this: If sentencing is the pivotal event, you've got your PSI done, don't forget about the waiver side. You've got your PSI done, you do sentencing. Is there anything that can be done statutorily, administratively, or otherwise that would ensure that that PSI is there at sentencing, and at sentencing we have a sentencing order and judgment that comes out post haste? At that point, the decision in a large part is going to be made at that hearing. Some can be reviewed otherwise, but largely they're done then. Make sure we get the quickest turnaround. What is the quickest turnaround to get that handed over to clerk process to DOC so that they start their timelines? It doesn't mean that that's going to be the fix, but this is one point that there may be a handoff of the baton that might be able to be tightened up.
Well, we always send a commitment order with them immediately. So as soon as they're sentenced, they're committed, and we write it just on the, on the bottom. We send it off, and DOC already has the PSI, and so they know what's happening, and that's that day that they're walking out of the courtroom. And then, of course, the intricacies of preparing that order is reflective of mostly your calendar and your dockets.
I understand. So if I may, Mr. Chair.
You may.
So it's a simple question of, is there anything that can be done, whether it be statute or otherwise, that shortens the time period or tightens the time period within practical realities, that at sentencing, as quickly as possible, everything is processed and over to? Now, we've heard some testimony, if I recall correctly, outside of your purview particularly, but as soon as you have a sentencing and sentencing order judgment, it may sit at the clerk's office for a bit. Don't know, but we've heard that. So is there any way to make sure that that baton handoff is as efficient and as timely as we can? You may go, no, considering all circumstances, there's nothing else we can do. Fair answer. It doesn't even have to be today. But that's really the point I'm trying to focus on. Now, there's a separate point of how much more quickly can we get PSIs done? That's a separate point, and that's not for y'all.
Sure.
Right. But I'm looking at that handoff because nobody can finalize a sentencing order except for y'all.
Extra staff. I do think that education of the judiciary, and like I said, we just had a small conversation about it with the chief at our college, and I think that you can see, and that was even after our numbers in October skinnied down. So I think a lot of it is just, notice. And, when everybody's got all these electronics they tell me I'm supposed to use, the question is nobody's buzzing me going, you're late for a very important date. So, certainly some automation in terms of how far out you are or what you need to do is always something that we look to. And then the rest of it, most of it, what I've looked at is really anomalies. So I think that, if you're within a 7 to 14, even a 30 day, because again, sometimes you will not be in office for other reasons, is not bad. Everything outside of that is certainly something that we should always be aware of. If we could do it more quickly, we would. Some weeks I get mine in by the end of the week and they're done by Friday if I can. Other times, depending on what's going on, it takes a while. So perhaps just awareness and I don't know, legislatively that you can, because if you make it mandatory in terms of time, then all those other things that have to occur in my office will, and a civil attorneys already complain because the criminal dockets are so large. You would just take all of that and really push that almost more to the background.
So may I follow up with that real quickly?
Yes, you may. Like I said, I consider you the expert on this panel, Mr. Chairman.
Thank you. So maybe not a statutory addressing of the issue, but is it something that could be worked on with AOC and clerks so that there is an automated notice to a judge when something's at 7 day, when something's at 14 day, when something's at 21 day, and then there's a mandatory red email that goes out when you hit 28 days, that type of thing.
We're all, I have stickies on my door out the way, walking out of my office going, do this now. So I think anything that we can do to establish efficiencies on our side, we're more than happy to look at. I know the AOC is, and they've got all that technology. So
if there's a notice that goes out, then there's a way for the clerk's office and the AOC to track judge by judge, month by month, whether the 7, 14, 28 days is, where's the target at, where's the curve at. that would help us understand and help you able to monitor yourselves
Oh, yeah.
and get the feedback.
Yeah.
I don't know that will be sufficient, but that it might be a good step, though.
And maybe I'm sorry.
Go on.
I was just saying, maybe Representative, we've worked with you before on other issues in which I think that sometimes information gets provided to you, and then when we start defining things and we start looking at things, we see that maybe the problem doesn't exist as big as it may seem.
Yep.
And so perhaps, just a good conversation to dig in to those cases and find out what that date is. Because if they're using the plea date.
Yeah. See, I'm not interested in a plea date.
Right.
I'm
but if
interested
that's
in
what they're
sentencing date,
using, then that knows we don't have a problem. But so I think just maybe if we could pull the thread a little bit, but I definitely think we would love to work with you more and see if you have other suggestions. I think, like you said, I think it's always good to improve the efficiency of our.
I think that's primary, because when we went back looking at these stats, they're all running off the guilty plea date. They're not running off the sentencing date. And so all the sentencing dates were, and these cases, and I brought them so you can look at them, they're public record, are within just a real skinny amount of time.
Yeah.
But the 72 days they were talking about was running from guilty plea to sentencing, and then the sentence. So we were having trouble trying to figure out what the real lapse is between me sentencing and the actual order going out. So auditing that would be helpful.
And one other thing, you probably know this, but like if someone comes before the court for sentencing and give an example, you might have someone who comes and they're acting very strangely. And then you start to realize it's maybe mental health, not just, could be substance abuse, but mental health. And perhaps you want to get a mental health evaluation. Yeah. It would take us about 4 weeks to get a mental health evaluation. So you don't want to just sentence and probate and send them on their merry way where if they're a low risk, they're only going to see their probation officer every 3 months. Every 3 months. So you're really not supervising these people, in my humble opinion. But then if you want to do a substance abuse specialist evaluation, it takes another 4 weeks to get that evaluation. So some of that delay also, probation and parole work really hard.
Yeah.
This is not, please don't take any of this as a criticism of any of the how long it takes to get a PSI or how long it takes to get a substitute. I'm not doing that. I'm just saying that that's the reality of what it takes.
Yeah.
So
yeah.
Yeah.
Mr. Chairman, just to comment, if I may,
You may. Go ahead.
I want to make sure we're clear about this. P&P is a workhorse that
Yes.
goes unrecognized
Yes.
on most
Absolutely.
every day, and they are an overworked
Yes.
workhorse, and we call on them more and more, and probably will be
Yes.
calling on them more and
Yes.
more. Want to bring them to the table and make sure they know,
Yes.
but they are the workhorses that deal with the PSIs
are.
and deal with so much. That's why I try to focus on sentencing at
Yes.
this point as opposed to guilty plea date. We can always watch it, but the sentencing is the key. Thank you, Mr.
thank
Chair.
you.
You're welcome. And we all want to be nice and not say anything bad about anybody, but the fact of the matter is, I don't care if it's judges, jailers, or probation and parole, you got some good, and then you got some that aren't working so much. And then that's just the way it is. And that's why I really, Chairman Petrie, we have even one or two concrete things we can do, and I hate to put something in statute about it, but I'd really be interested in your input and the judge's input, because this is something we hear about all the time, and if we could move the needle, just that one thing would be huge.
Thank you.
Thank you.
And you're welcome. Well, let's see if there's any other questions. Chairman Petrie's dominated. Any other questions?
We were so articulate, you don't have any questions.
That means you've done an excellent job.
Thank
But
you,
stay
guys.
here in case we need to call you back.
All right. Appreciate it.
Okay, I don't want to go over an hour, and we're at about a little over 30 minutes, so we're going to move to the next item on the agenda, the Department of Public Advocacy. It's always great to see them here, another friend of the task force, the waiver of the pre-sentence investigation. And why don't we have, I want to make sure the jailers are in on this conversation too. I don't know who wants to be the spokesman, but get up here in the front row, whoever does. Welcome. I have some new faces. It's good to see you. Introduce yourself for the record and proceed with your testimony.
Good morning. My name's Melanie Lowe. I'm General Counsel for the Department of Public Advocacy. As I understand it, we're meant to testify this morning about reasons why defendants may waive PSIs and proceed at plea as opposed to sentencing. To be clear, we're talking about waiving presentment of PSI prior to sentencing. Of course, everyone has a PSI that is completed either before or after sentencing, depending on a waiver. In my estimation, there are 4 sort of discrete circumstances that lead to waiving of a PSI, and then a 5th sort of catch-all that I'll briefly touch on. The first doesn't have anything to do with classification, because the first reason that I'm aware of that clients frequently waive PSIs is to get out of custody. So on Monday, I was in court and visiting a county, and there was a lady there who was pleading guilty, and the plea agreement was to be probated and go to long-term treatment. The judge in that location tends to, as I understand it, have a general policy that he will not release anyone at the plea, even if probation is the inevitable outcome. He requires the person be sentenced prior to release. So that woman, for example, was very heavily incentivized to proceed with sentencing on the day of the plea, because she did in fact then get sentenced, ordered to probation, and she's now, I assume today, in a treatment bed, where otherwise she would have been in the jail for another 4 to 6 weeks. So that's number one. The second reason that I'm aware of that waivers somewhat routinely happen is for people, KRS 532.110 indicates that certain classes of inmates can be held in a county jail. Other classes of inmates, particularly A and B felonies, must be transported to a correctional facility. I have had many clients in the past who, after charged with relatively serious offenses, who've been in jail for months or in some cases years, by the time they reach resolution, they feel they want to be done and get to the correctional facility. And so by waiving the PSI, they move faster to the facility, because the corrections department has 45 days to transport them after sentencing. So if they can move the sentencing up, they get to corrections faster. The third reason that I'm aware of, which I haven't personally seen, but we did a quick survey yesterday and found that this is happening somewhere in the state, is that prosecutors in some places are conditioning waiver of the PSI on a plea agreement. The way that I'm told that this happens is a prosecutor will show up to a docket and have sort of a flash sale where they give a very good offer, which the defendant wants to take, and conditions of that offer are: you have to plea today, you have to be sentenced today, you must waive your PSI presentment. And so, faced with the choice of not seeing the PSI or getting a heavier sentence, they choose a lesser sentence and waive the PSI. Another scenario where clients occasionally seek to waive PSIs is related to shock probation. There are judges that have a very different standard, I think, for probation versus shock. And there are clients who feel that it's best to waive the PSI and be sentenced, because they think they won't be probated at the sentencing, to start the clock so that 30 days passes faster, so they can then file for shock and get probated. Then the fifth reason, it's sort of a catch-all, is there are a lot of personal reasons that our clients will occasionally want to waive PSIs. Sometimes people are housed across the state, and the cost of not seeing their PSI is less to them than being shackled and searched, invasively searched. There are times when people simply want closure themselves. They've been through a long process. They've negotiated the case. Once they know what's going to happen, they just want to be done with it and move on to whatever comes next. And then there are jails where, even if DOC classification has not occurred, a lot of clients are, after sentencing, permitted by the jailer to work in the jail where they previously weren't, or to be placed in a different unit than they previously were. And so there are some local benefits occasionally that clients take advantage of. And
explain that. You lost me there. So you're saying there's an advantage to the prisoner. I call them prisoners, not clients. There's advantages to the prisoner to waive a PSI to work in the jail. Explain that to me.
My understanding is there are some jailers.
Because you're exactly right. They love to work in those kitchens and stuff.
Yes. My understanding is there are jailers who, once they receive notification that a person is pled guilty to a felony and will become a state prisoner, we'll go ahead and move them into, even if they're not getting credit, if they're not getting the benefits of the work the DOC would give them, they still get the local benefit of just being out of the cell and working.
Sure, it's a big deal, but what's the PSI have to do with that?
Well, by waiving the PSI, they get sentenced on the day of their plea. And so they can start that work 30 or 45 or 60 days earlier than they would if they waited to be sentenced.
Got it. Thank you.
I appreciate you having us here to discuss this issue. In the 18 years that I worked as a trial attorney in DPA offices, waiving a PSI was not something that I did routinely, but it did happen in the circumstances that Mr. Cox has indicated. I do think it's important for you all to know, and I don't want to assume that you don't know this, but that the preparation of the PSI is a very time-intensive process. Usually our clients are given a packet of information, I don't know, 20 pages when they plea prior to sentencing, and then they're expected to go back to the jail and fill that out completely. I do think that's a difficult task for some of the clients. I've had to go to the jail for clients with language barriers, for clients with educational issues, to go and actually assist them in filling out that PSI paperwork. And then until that's done, probation and parole, whoever writes the PSI at their local office, is not able to complete that. And it's all done by hand. So the clients have to write that out. They have to look at it and enter it into the system. And I do think that is very work intensive, in addition to reviewing their entire history, criminal history, and putting that in there for in-state and outside the state. There's no automation to that for local probation and parole. So that is sizable. Sometimes it presents problems in getting that prepared, just because you have clients who are illiterate or have language barriers or educational issues. The other delay I think that happens is a lot of times we have to review that with clients. And when we review those with clients, most of the time I did not receive those. If I received them a week before, that was a very long time. Sometimes I was receiving those the day before, and we have to review that with the client to ensure that information is accurate. And if there are corrections or changes, sometimes I had clients who didn't want those corrections to be made because they wanted to go ahead and be sentenced for the variety of reasons that Mr. Cox has indicated. I do think that a lot of the issues are localized, and I do think staffing issues within local probation and parole offices, with judges' offices, but I have found that all of those folks are working very hard to get the paperwork moved, but there are a variety. I think the survey that we sent out to our staff indicated that there are some places in the state that there are definite holdups in getting those sentencing documents, getting the PSIs done. And I think that probably has to do with localized issues related to staffing. But those are the elements that I wanted to mention as it relates to our work with clients in getting them to sentencing as quickly as possible, because by and large our clients are very motivated to get sentenced and get that behind them for all the reasons that we've indicated.
Chairman Petrie.
Thank you. One, I want to make sure that a point that was made earlier with the prior panelists, defendant can waive presentation of the PSI. The PSI has to be completed, number one. Number two, even though the defendant waives the PSI, the judge can receive the waiver but still mandate that the PSI be considered before sentencing occur. So there's another backstop there. Okay. So let's say a PSI is waived. Judge goes along with it, processed. In 25 years, I've never waived a PSI. So what process is there on the back end for an attorney to be involved in making sure that PSI is accurate as you would do before sentencing hearing and reviewing the PSI with your client?
That's the primary reason that I haven't done that a lot in my practice, is for concerns with regard to that information being correct. Yes. And for clients who wish to waive it, it's always a situation in which, as a legal professional, we have to advise the client those pitfalls. Mm-hmm. This is a document that's going to follow you throughout your life if you end up back in the criminal justice system, and so it has to be correct.
So no mechanism, process for checking it afterwards if it's waived their sentence and moved on.
We are not provided with those documents if they waive those. That's correct. Yes, sir.
So, Mr. Chair, if I may.
You may.
So I want to make sure I'm clear. So if it's waived and the waiver is accepted and sentencing occurs, PSI is going to be done by DOC at a later date. It's just DOC and the inmate at that point that is reviewing for accuracy with no counsel involved and no outside sources involved. It's just that and that alone.
That is my understanding of the process in all the counties.
All right. Want to make sure. Thank you.
Yes, sir. Thank you.
You're welcome. Anyone else? What if, and judges, you jump in here too, because I'm afraid to ask this, but what if we didn't waive any PSIs? What would that clog up the whole system, or what would be the result of that?
So the judges may want to weigh in, but I think if I think some limitation would be reasonable. I agree with the notion that rarely waiving them is appropriate. However, for examples like the first one that I gave, where someone is going to be stuck in jail for an extra 4 weeks or 6 weeks or 8 weeks, when they could be in treatment, I think there should still be an avenue for those people to be able to get to treatment as quickly as possible. And so I think some waiver, some knowing waiver with counsel's assistance for good reasons should be permitted.
Counselor, are the provisions in that right now in statute, regulation, where are they at?
The only provision is just 532.050, which says that they can waive a written waiver as long as they're in custody. I'm unaware of anything. Well, there's also a criminal rule 11.2. I might be getting that wrong, but it cites back to the statute and says that waiver is possible.
Senator Wheeler.
Thank you, Mr. Chairman. This delay, does that delay when the PSI is not waived, if we had to wait to complete every single one of those, would the county still be responsible for the payment on that inmate until such time as the judge receives it and formally enters the sentencing on that? So, I mean, would this be an additional financial burden to the local government?
It would be, and in fact, that's something I should have said when I was referencing the plea negotiation reason for waiving. I believe the attorneys and the prosecutors in those jurisdictions are heavily weighing the cost to the state in making the decision to make the offer contingent on waiving.
Thank you, Mr. Chairman.
You're welcome. But consulting with staff for just a minute, if the committee will stand at ease. Anyone else have any questions of this distinguished panel? Does the jailers have anything to add?
You know, I always got something to say. But I would have wore a shirt and tie if I knew I was up here speaking today, so I apologize.
You
for
look
that.
just fine.
I appreciate that. You know, one thing we talked about in the second meeting of this committee was, you know, when they talked about waiver of the PSI, whenever the DOC was up here speaking, and the look on Representative Petrie's face and Senator Westerfield's face whenever they said that automatically a prisoner, when they waive their PSI, when they get to prison, when they finally get to the rotor to get classified, it automatically bumps up their security level. You know, that's another thing that, you know, needs to be explained to any client of any attorney's office. You know, before that, so you know, because they're sitting in limbo for a long time. The second thing I'd like to add is that. I just wanted to let you know that, you know, of course, the KJ has always had representatives here for every one of these meetings, just to throw that out there. So, but I appreciate y'all.
Well, we appreciate you being here. And judges, I saw you nodding your heads. Did you have something to comment on that?
Just so you know, I think the only thing I was going to say about sentencing is that
Step to the mic, please, so you're on the record.
Thank you.
only comment I wanted to make about the judge deciding maybe to not sentence until he has the PSI is that, you know, a judge may want to decide if he wants to do probation. And even if you are going to do probation, the defendant cannot get into a treatment program by DOC until he's sentenced. So, you know, to tell the judge, go ahead and accept the recommendation without the PSI or the waiver of it, the judge is basically not going to release them to a DOC bed that they cannot get into. So, you know, the judge has to have the sentencing order go into place. That's probably why the judge is saying, I'm going to wait to sentence you before I release you, because otherwise he's releasing a person who we know desperately needs inpatient treatment and without it is very likely to use and pick up new charges and bail jump, and it just, the process goes on and on and on.
Thank you, Judge. State your name for the record.
I'm Judge Julie Ward. Thank you.
Judge. Committee will stand at ease. Are there any other questions or comments? Very well.
No, I just wanted to put the rule on the record. It's 11:02.
11:02.
Thank you, Judge. The committee will stand at ease while I consult with my co-chair.
You know, I'll tell you this, we have a great work.
Thank you. At this time, co-chair has a statement.
Just want to say thank you to everybody that's presented from the first meeting up until now. You know, we've heard from judges and jailers and fiscal courts, and we really do appreciate this. This isn't an issue that's got, you know, just a simple piece of legislation can get filed to fix it. I mean, there are issues across 3 different branches of government, and it's extremely complicated, a lot more complicated than what I'd originally thought. You know, because apparently I thought, you know, if you increase the per diem, it takes care of everything, but that's not the case. But
it does.
Yeah, yeah. But I do want to say one thing to the jailers and the judges, and not specifically the ones in here, but the ones, you know, throughout the Commonwealth. I've heard from several of you that are thinking about, hey, we want to get out of the jail business, but we can't do it. Or, hey, we need to build a bigger facility, but we can't afford to do it. Or, hey, we've got to make a change somewhere. Hey, there's an opportunity here. And so, you know, I see Jim Henderson here, and I saw Todd somewhere earlier. And so what I'd like to say is, if you could get, and Renee, if you could get word to your members that, hey, if you're thinking of getting out of the jail business, expanding, doing something different, or, you know, hey, we've got an opportunity here, please reach out to me. I'd love to sit down and talk with you and see what we could do collaboratively. You know, one of the things I've learned, you know, Jim said this at the first meeting, that if you've seen one county, you've only seen one county, and that's a fact. So I, once again, just want to say thank you, and please, you know, reach out if you've got any recommendations.
Thank you, Co-Chair Bray. I want to thank you for your patience, and it's been great working with you, and say ditto to everything you've said, because there are, it's a lot of moving parts to this. And as I said at the first meeting, we're a unique state with elected jailers. There's no other place in the world that does that. I tease the president of our association. Not only is he president of the Kentucky jailers, he's president of the internationals, because there's no other place that does it as good as we do it. where the people can directly elect their correction administrator. We are going to adjourn. We may be having another meeting, requesting another meeting. It just depends on the recommendations we get. I'm especially interested in Chairman Petrie, some of your things, if we can get some of that in writing, that would be big. Of course, the per diem increase is something that I'm very interested in and want to propose. So, but we're going to stand adjourned this morning. Thank you all for your time, and it's been a great experience unless any other members have any questions or comments. Thank you all.